For the court is now in session.
Please be seated.
Madam Clerk of Court, please call the case before us.
Good morning, Your Honors. This is a continuation of the oral arguments on the consolidated petitions in GR number 271059, Representative Edsel Lagman, as substituted by Albay 1st District Representative Crisel Lagman et al. Versus the Congress of the Philippines et al. GR number 271347, Aquilino Coco Pimentel III and Pantaleon Bebot Alvarez versus Lucas Bersamin in his capacity as then Executive Secretary et al. GR number E-02472, Filipinos for Peace, Justice and Progress Movement Incorporated or FPJPM, as represented by its President and Chairperson, Mr. Joseph Cadsawan, and Chapter Officer, Ms. Gloria Puzon, versus House of Representatives et al. And GR number E-04036, Edgar Erice and Laila de Lima versus the Senate of the Philippines et al. Thank you, Your Honors.
Appearances, please.
Good morning, Mr. Chief Justice, Senior Associate Justice, members of the Supreme Court, respectfully appearing for Petitioner Lagman in GR 271059, Attorney Lorenzo Tañada.
Good morning, Your Honors. I am Attorney Elmar C. Barreda of the Lagman Law Offices, and I am respectfully re-entering my appearance as counsel for the petitioners in GR number 271059. Thank you very much, Your Honors.
Good morning, Your Honors. Jericho Salenga appearing as counsel for Aquilino Coco Pimentel III and Pantaleon Bebot Alvarez. Thank you, Your Honors.
Magandang umaga, Your Honors. Attorney Joseph Lemuel Bakiran, respectfully appearing as counsel for petitioners FPJ PM, Your Honors.
Good morning, Your Honors. I'm Attorney Renelyn Arellano, appearing as counsel for petitioner FPJPM. Thank you, Your Honors.
The Honorable Chief Justice, Senior Associate Justice, and Associate Justices of the Supreme Court, good morning. I'm Attorney Vapetro Angie Peña. I'm representing petitioners in GR number E-04036, Representatives Edgar Erice and Laila de Lima. Together with me is Attorney Janessa Mariti Codera and Attorney Bianca Isabel Soriano.
Good morning to the Honorable Chief Justice, to the Honorable Senior Associate Justice, and to the Honorable Associate Justices. I am Attorney Bianca Isabel D. Soriano, respectfully appearing for petitioners Erice and de Lima. Good morning, Your Honors.
Respondents, please.
Good morning, Your Honors. Good morning to our distinguished amici. The Office of the Solicitor General respectfully re-enters its appearance on behalf of the respondents in these consolidated petitions. I am Solicitor General Darlene Marie Berberabe. With me today, Your Honors, are Assistant Solicitor General Marisa B. de la Cruz Galandines, ASG George Ortha II, ASG Jennifer F. Anjalan Legaspi, ASG Samantha P. Kamitan, ASG Orlando P. Polinar. Other lawyers of the OSG are in the gallery to provide assistance whenever necessary. Also with us are DBM Assistant Secretary Romeo Matthew Balangkit, the DBM's representative to the Development Budget Coordination Committee or the DBCC, DepDev Assistant Secretary Roderick Planta, the DepDev representative to the Investment Coordination Committee or the ICC, other representatives from the DBM and from the DepDev as well as from the Bureau of the Treasury are also in the gallery. Thank you.
Madam Solicitor General, may we know if DBM ASEC Secretary Angel Magtalas is around?
Your Honor, she is not around. She is on leave, but Undersecretary Janet Abuel is in the gallery.
Okay. Because Justice Kagiwa requested for her presence because she prepared questions specifically addressed to ASEC Angel.
It was manifested to me by ASEC Angel that she has I think she's on leave, on personal leave.
Okay. Sige, we'll take it from there. We'll find out later if USEC
Janet Abuel,
can
Your Honor.
respond to the questions.
Okay, thank you.
so much. For the record, appearing as Amici Curie are Attorney Florencio B. Abad, Professor of Praxis, Ateneo School of Government, Honorable Franklin M. Drilon, former President of the Senate of the Philippines, Honorable Benjamin E. Jokno, for Member Monetary Board, Bangko Sentral ng Pilipinas, and Honorable Jose Maria Clemente Joey S. Salceda, former Representative and Chair, Institute for Risk and Strategic Studies Incorporated. I understand, Congressman Salceda, that would you like to make some manifestation? Please proceed.
Diyos malay na aga po, Senator Campos. Good morning. Actually, mahaba to, pero I decided to compress it. May budget tayo dahil kailangan natin palakihin ang ekonomiya at para po gumanda ang pagkabuhay ng tao. Yung size ng ating budget ay marami pong mga hindi na limitasyon, kundi meron din nag-enable. Halimbawa, yung mga buwis na nasisingil natin sa mayayaman, halos hindi naman nasisingil. Tapos, kung iisipin mo po, kung ibenta mo po yung Manila Bay, 23 trillion po yan. That's 10 times the GDP of the Philippines. So, hindi ho ganun kahirap ang Pilipinas. Katulad ng Japan sa Chiba, yung 28% nung Chiba Bay, halos kasing laki na ng budget po ng Japan. Ang sinasabi ko lang po dito, may budget, may pagkukunan, may pagkakagastusan. So, yung pagkakagastusan, may mga limits nasa konstitusyon, nasa kung saan. At saka, kahit nga po itong sinasabi natin ito pong unprogram appropriation ay hindi po talaga limitasyon dahil sa power of the purse. Kahit saan mo papuntahin yan. Basta po may sasalo po. O hindi po siya magiging, how do I call it? It will be an indefinite or virtually fictitious limitations to the power of the national government or the spending or the executive. So, pag sinabayan mo po yan siguro sa greed o sa swapang, kaya nagkakabulbul po ang ating problema. Kaya ang sinasabi ko talaga dito, at the end of the day, ang pinag-uusapan natin dito, kung gaano kalakas ang ating mga institusyon. Yun lang po. Maraming salamat.
Thank you. The manifestation is duly noted and recorded. Justice Chapardi Mampa will resume his interpellation. Please proceed.
Thank you, Chief. May I request the Honorable Senator Drilon to take the podium and answer these few questions.
Thank you, Your Honor.
Good morning, sir. You mentioned in your opening statement that while the act of classifying funds either as program or unprogram is the exercise of the power of the purse. However, you also mentioned that there are costs which are foreseen operational, which must properly be included under the program appropriations. Using this as a standard, will the unprogrammed appropriations then be likened to a fund similar to a contingent fund as it covers costs which are unforeseen?
I'll try to answer that, Your Honor. In my own judgment, the unprogrammed appropriation refers to programs where the funds are not immediately available, but could be available if certain conditions are fulfilled. With that, Mr. Justice, may I have the privilege of trying to understand your question, sir?
Let me cite the case of Belhica versus Executive Secretary, 864 Philippine Reports 461, promulgated on October 8, 2019. In that case, the Supreme Court made mention about contingent funds and program appropriations. I could vividly recall that in that case, it enumerated 11 projects which may be funded by unprogrammed funds, and the court also mentioned about contingent fund, which refers to urgent projects and activities. Precisely, I'm asking you, my next question is, what is the clear-cut distinction between unprogrammed appropriations and contingent funds?
The contingent funds, to my understanding, is designed to respond to contingent events. Example, from my understanding, if a storm suddenly hits the country, if the calamity funds are not enough, the President may look at the contingent funds because the destruction caused by a storm was not predicted, and therefore that is precisely the purpose of a contingent fund, Your Honor.
So there is no clear-cut jurisprudence as to the distinction between program and program appropriations and contingent funds?
None to my knowledge, Your Honor. That is why we're here today, and as I manifested in the last session, I said, this is a case of first impression. I am not aware of any case where the matter of unprogrammed appropriation was precisely brought before this honorable court.
Assuming that the court takes the position that there must indeed be substantial distinctions between programs, between project or program under the program appropriations and program appropriations. As such, the court decides to define what unprogrammed funds are and introduce parameters on the projects identified therein. What do you think, sir? Would this constitute a violation of the doctrine of separation of powers?
My respectful submission, Your Honor, is that if the grant of the power is constitutional, then there is no basis for guardrails being imposed by this court, with all due respect. Because if the power is constitutional and the power is granted to the Congress. Our respectful submission, Your Honor, is that the principle of separation of powers would prevent the intrusion into the powers of Congress, even by this honorable court.
Could this be validly justified under the expanded judicial power of review under Article 8, Section 1, Paragraph 2?
I think it's a question of to what extent this honorable court will exercise such expanded jurisdiction. It's all addressed to the sound discretion of this court.
Sir, you also advance the view that program budget must first be completely covered by any funding before excess could be declared for the purpose of triggering these unprogrammed appropriations. Correct?
I'm sorry, Your Honor. Can I have it again? I am a little difficult on hearing. Will the Honor give us?
You also advanced the view in your opening statement that program budget must first be completely covered by any funding before any excess could be declared for the purpose of triggering unprogrammed appropriations.
Yes, Your Honor, because when the budget of expenditure and sources of financing is submitted to Congress by the President, in that submission would be the crucial source of financing for the funds which are programmed. And that is why the unprogrammed portion of the budget was crafted in order to address the issues or address the needed appropriations if the conditions are complied with.
In this regard, you subscribe to the view laid down in that case of Araulio versus Aquino. 737 is Philippine Reports 461, the 457, that it would not be it would be an unsound fiscal management measure to declare an excess, simply to declare the release of unprogrammed funds simply because there was an excess revenue at one source.
Yes, our submission, Your Honor, is that the excess revenue must be reckoned from the whole budget and not the individual sources of revenue. What has happened, Your Honor, is that the Department of Budget has taken sources of financing individually rather than the whole government, so that it justified its releases on the unprogrammed appropriation on the excess of collection of individual sources of revenue rather than the whole government.
To recall, the court's ruling in Araulio is anchored on the interpretation of the phrase revenue collections should exceed the original revenue targets.
That's correct, Your Honor. It should exceed the original revenue target. But as I earlier pointed out, it has been the original revenue target was reckoned on an individual revenue source system rather than the whole revenue target of the entire government.
So here before us are petitions which may involve release of unprogrammed funds. And it would appear that it may be permissible if one of the conditions laid down in the 2026 GAA, Chapter 43, Special Fund, are satisfied.
Yes, Your Honor.
In this being so, is it a political question to choose whether we apply the individual standard or aggregate standard?
The question, is it a political decision
Question.
or question if we apply the
Individual standard or the aggregate standard?
I think, Your Honor, the Constitution, to my recollection, only says that the unprogrammed revenues or the program activities can only be funded from excess of revenue. The issue in these cases decided by the court, by this honorable court, is whether or not that revenue pertains to the revenue of the government as a whole or individual revenues. My submission, Your Honor, subject to my submission is that these are legal questions that the court can look into, not a political question.
Let's make a comparison. Under GAA 2026, Chapter 3, under that special fund, it made mention about this excess revenue collections in any of the identified non-tax revenue from its corresponding revenue collection target as reflected in the BSF. However, in the case of Arroyo versus Executive Secretary, it made an interpretation, as I have just quoted, revenue collections should exceed original revenue measures. Can you point out the glaring distinction between these two?
It is my respectful submission, Your Honor, that the Arroyo decision is an interpretation by the court of a constitutional provision and therefore may not be amended by an act of Congress as it did in the case of I think it's 2024 General Appropriations Act. Just to reiterate, the decision of this honorable court in the Arroyo decision is an interpretation of the Constitution. And therefore, in that sense, the provision of the General Appropriations Act, which allowed the Department of the Budget to look at individual sources of fund, to me is improper and unconstitutional.
Is there a constitutional provision which serves as a basis to prohibit the use of a trigger mechanism based on the excess of individual revenues?
My submission, Your Honor, and this is my individual submission, is that these are questions which the court, if I may suggest, carefully examine because the line is not very clear, Your Honor. And that is why all of these issues are being brought forth because the public, the Congress and the executive branch are not very clear on what the parameters are. And I am conceding good faith to them that it is a question of interpretation and therefore there is need for the guidance of this court.
Sir, do you think we should limit the number or the nature of projects and programs that may be included in the program appropriation in order to prevent Congress from indiscriminately transferring projects from program appropriations to unprogrammed appropriations?
As a friend of this court, I would strongly advise against such temptation to impose that kind of a limitation, Your Honor.
to illustrate, the 2024 GAA has 51 purposes, while the 2026 GAA has 3 purposes after the presidential veto. Do you think there is post-enactment discretion with respect to the use of unprogrammed funds between 2024 and 2026 GAAs?
It's difficult to answer that question straightforward, Your Honor, with all due respect, and I must apologize for not being able to respond directly, but as we said, these are questions which the court may want to look at. But at this stage, let me say for the record that this court may want to take a good look at that expanded jurisdiction of the court under the Constitution and determine to what extent this honorable court should exercise such expanded jurisdiction in the many instances that is brought before, or many in the cases that is brought before this court. We are aware that under our present Constitution, it expanded the scope of judicial review. Yes, it has done so, but my submission is that the court should respond to the question among themselves, to what extent would this honorable court exercise such expanded jurisdiction.
Thank you very much, sir.
Well, Your Honor, with your permission, may I read a manifestation for the record in relation to the questions raised by the good justice.
Please proceed.
Thank you, Mr. Chief Justice. Your Honors, throughout these proceedings, it has been my position that unprogrammed appropriations are not inherently unconstitutional and are in fact necessary tools for budgetary policy. For decades now, Congress has included unprogrammed appropriations into our budgetary framework while satisfying the constitutional requirements for an appropriation. Your Honors, the 1987 Constitution expanded the scope of judicial review to include the determination of grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. That's what our Constitution provides. That's why I said earlier, this honorable court is confronted with the question, to what extent should this honorable court exercise such expanded jurisdiction? By expanding judicial review, did the framers intend to authorize this honorable court to review all acts of the government? Or did they instead seek to ensure the grave abuse of discretion could be corrected without eliminating the doctrine of a political question and without disturbing the areas the Constitution principally entrusts to the judgment of our executive and legislative branches, such as the enactment of the national budget? It is my humble submission, Your Honors, that the power of appropriation or the power over the purse was vested by the Constitution on Congress to determine how public funds are to be allocated. Indeed, the courts do not ordinarily inquire into the wisdom of just choosing, for example, funding a hospital over intelligence activities, or funding roads over subsidies, and generally in choosing which public purpose holds more importance and prioritization and method of funding. These are policy judgment we submit, Your Honors, entrusted in the appropriate political branches who, by constitutional design, are in the best position to determine the priorities that they represent. The same principle applies here, Your Honors. I recognize that the concerns raised by the petitioners in this case are not without basis. There are legitimate questions regarding the substantial increases in the unprogrammed appropriation in recent years, the movement of projects from program to unprogrammed appropriations, the breadth of the bicameral conference committee's actions, and the standards governing release of funds. However, in differences regarding policies behind the budgetary process and the existence of concerns regarding its eventual implementation do not necessarily render the underlying constitutional mechanisms invalid. To illustrate, Your Honors, suppose Congress decides to reduce confidential or intelligence funds and instead allocate the same amount to the construction of public hospitals. Few would argue that such an act is unconstitutional. Whether one agrees or disagrees with that policy choice is beside the point. Your Honors, I am not a scholar on the Constitution. I am not a constitutional law expert, far from it. I am a politician, and I am not ashamed at being a politician, Your Honor. But in my 24 years in the legislature, and in the Senate in particular, what I have learned is that adherence to the Constitution is a standard which, by and large, senators would follow. Yes, there are abuses committed, but is the remedy to deprive Congress of the power to formulate policies and appropriate funds in pursuit of that policy? Should this honorable court find that there was indeed grave abuse of discretion, I submit that the remedy is not to deprive Congress of the powers vested in that body by the Constitution. There are remedies available under the constitutional framework. For instance, the President's exercise of his line item veto and administrative charges against those who abuse their powers, while those who have abused their power of the purse must rightfully suffer the consequences of their greed. The problem brought about by unprogrammed appropriations will not be resolved by depriving Congress of its constitutionally mandated power over the purse. That is our humble submission, Your Honor. Just as a final point, Your Honor, as I have previously manifested, I once more urge this court to decide on this very critical question, especially since the 2027 budget will be submitted to Congress 30 days from the SONA, which will be held at the fourth Monday of July. That is our submission, Your Honor, so that all parties, all the public, will be guided by the wisdom of this court in resolving this very difficult issue. Thank you, Mr. Chief Justice. Thank you to the Honorable Justice of this court.
Thank you, Honorable Drilon. Your manifestation is noted. You may continue.
May I ask Secretary Abad to take the podium? A few questions to answer this. Morning, sir.
Good morning, Your Honors.
Morning. You mentioned in your opening statement that in funding and program appropriations, reality forces three decisions. Namely, one, which appropriations will be funded, two, which will not be funded, and in what amounts. Given these three decisions, would you say that in light of too much discretion involved, and program appropriations may partake of the nature of pork barrel?
That's one of the consequences if this mechanism stays in the budget, and we do not know what else may happen. I said that point, Your Honors, because if you look at the fiscal condition of the country, the rule is we never really have excess collections of revenues or budget surpluses. In fact, as I earlier mentioned, there have been only 4 instances in our history where we had budget surpluses, and this was the time of President Ramos in 1974, 1975, 1994, 1995, 96, 97. And on the average, it was only about 9 billion pesos surplus. The last time we had excess collections of revenues was still in the 70s. Although there was a claim that in 2024 we had excess revenues, but that's only because we included the cash extractions from PhilHealth and the PDIC, which increased the revenue. But those are not really, strictly speaking, cannot be characterized as tax revenues. If there were instances in the past where excess collections were in fact certified by the executive, it was more because we did not, as Arroyo now dictates us, we did not look at the streams of revenues holistically, and we look at them separately. That's why in many instances, excess of non-tax revenues was used as a trigger to activate the unprogrammed fund, which is now no longer possible. But assuming that that's still possible, in case there is excess collections, usually it's not enough to fund all of the unprogrammed appropriations expenditures authorized by Congress. So what happens is post-enactment, a decision has to be made as to which of the authorized expenditures should be funded and to what extent, and which should not. And my position, my contention is that this is post-enactment and happening during the period of budget execution, and therefore that power is exercised not by Congress, which has exclusive jurisdiction to do that, but by the executive. That's why I said it creates confusion or a problem, Your Honor.
Sir, in practice, who makes these decisions?
Well, under our Constitution, for example, during the period of budget enactment in the enactment of program appropriations, it is the legislature who must exercise that function, Your Honor.
Yeah. Are there established parameters that they should follow, if any?
Well, one guardrail is that in case of amendments in the budget, it should not exceed the budget ceiling that was provided by the executive. Number 2, care must be given so that the cohesion in the fiscal program is not undermined or disturbed, because the Constitution mandates the President to prepare a national executive program which shall serve as a basis for the general appropriations bill. So therefore, care must be given so that the fiscal program prepared by the President is not distorted or undermined, Mr. Chairman. Your Honor.
Secretary Diokno mentioned last week that the unprogrammed appropriations should be limited to foreign-assisted projects. Do you agree that this is the way to move forward to prevent unprogrammed appropriations from becoming a new pork barrel?
in the narrowest sense that may be possible, Your Honor, assuming there is no mechanism that is in fact provided by the Constitution, because under the Constitution, there is a way of dealing with that through special appropriations. And I think there are quite a number of advantages going the route of a special appropriation. Number one is textually, special appropriation is in the Constitution. And program appropriation, to my mind, Your Honors, was never in the contemplation of the framers of the Constitution. I went through the relevant provisions of the Constitution, and I don't see the word or the phrase "and program appropriations." I looked at the relevant debates on the Constitution with respect to public finance, and I never see the word "and program appropriation." Not even a concept that is closest to it in practice. Even structurally, the Constitution prescribes a complete, coherent finance fiscal program. And I think going through the route of the special appropriations will enable us to achieve that. Institutionally, going through the route of special appropriations will enhance the separation of powers and the independence of branches. While going through the route of program operations, it opens us up to the possibility that those functions may be confused. That's why we have seen in 2023, 2024, 2025, the extent of reprogramming of program appropriations that can happen may in fact lead to other possible similar fiscal, I might call fiscal adventurism. In 2023, about 395.5 billion of program appropriations were reprogrammed, were diverted. In 2024, about 564 billion of program appropriations were taken away and reprogrammed to other projects. In 2025, it was about 487 billion pesos. So this is a huge, unprecedented problem created by this mechanism, and we do not know if it had been possible for these diversions to happen. We do not know what else can this mechanism allow to happen, Your Honor. That is why I would rather safely stick to what is provided in the Constitution than risks another of these problems cropping up, which is at present creating a lot of the problems that we are seeing in the country right now.
Thank you very much, sir. That ends my interpellation, Chief. Thank you.
Justice Rudil. Justice Rudil, please proceed with your interpellation.
Thank you, Chief. May I call on our Solicitor General for questions? Before I proceed, I would like to greet you a belated happy birthday. I think it's June 14. Am I right?
Yes, Your Honor. Thank you very much.
Happy birthday.
I spent the day po studying.
So, former Senate President Drilon mentioned about this already earlier. And I want to ask the position of the government on this. Is unprogrammed appropriation as a concept, is it a tool inherently designed to facilitate corruption? Or is it a neutral mechanism that may be utilized for corruption depending on its implementation?
Your Honor, the position of the government is that it is not inherently a tool for corruption. Number one, the unprogrammed appropriations has been present in our GAA since 1989. So from the presidency of President Cory Aquino until the current administration, the UAs, and twice in that period, have been considered by the Supreme Court in regard to its constitutionality or unconstitutionality. In Belgica versus Ochoa and in Araulio versus Aquino, the Supreme Court has given as well what are the parameters, when should an item be a valid item. And Congress has in fact followed, the Senate and the House of Representatives have followed religiously in regard to the Araulio versus Aquino. If I may also insert the position of the government, that our reading of the Araulio versus Aquino is that it was not a constitutional provision that the Supreme Court interpreted, but it was a statutory provision. It was a trigger in the GAA at that time, which led and which also was confirmed to us by the DBM to the revision in the articulation of a statutory trigger. Now, we all know as citizens of this country, many have been angered by what has happened in the 2024 budget. And I think that the political branches have also undertaken steps to course correct or to self-correct itself, because being political branches, they were also reacting to the emotion, to the public anger, and therefore they were also addressing the issues posed by the unprogrammed appropriation. Another reason, Your Honor, that I say that it is not inherently was designed to be a tool for corruption is that in many instances in the past, the administrations, the executive have actually relied on the unprogrammed appropriation, especially during the time of COVID, that President Duterte really tapped the funds on unprogrammed appropriations. Are they vulnerable to abuse? Our position is that any power, I would say, is vulnerable to abuse. And that's why we also tried to point out in the last oral arguments that the PDAF that was considered by the Supreme Court in Belgica versus Ochoa was in fact under programmed appropriations and not unprogrammed. So if there is really a intent, unsoundness or lack or absence of wisdom to our political branches, I think that any mechanism that is provided them or any power may be vulnerable to abuse, Your Honor.
Thank you, Soljen. Can I call on any counsel of the petitioners to answer the same question?
Are you excusing her?
No, not yet. Can stay there. Well,
Good morning,
yes.
Justice.
Do you want me to repeat the question?
Yes, please.
Is UA as a concept a tool inherently designed to facilitate corruption, or is it a neutral mechanism that may be utilized for corruption depending on its implementation? Or in short, do you agree with former Senate President Drilon?
I would agree with former Senate President Drilon. I would answer the question, it depends.
Okay.
Your Honor, it is clear that if the ceiling is fixed, the discretion of Congress as a former congressman is limited to what the President had submitted. And based on the petition of former Congressman Lagman, in the 2024 budget, that ceiling was breached exorbitantly. And now the question will be, why is this so? Is it because that members of Congress saw a possibility that this is a way now to circumvent the guardrails that the Constitution had provided based on jurisprudence under Bellica and Arroyo, to test and push the envelope? That may be.
So, we both agree here that unprogrammed appropriations are not evil per se.
Yes, Your Honor.
Para yung teknolohiya, technology is morally neutral. It is how we use it which determines whether it advances public good or it endorses abuse. Am I right?
Yes, Your Honor.
So this notwithstanding, do you want unprogrammed appropriations to be abolished and declared unconstitutional? Do you want it to be removed from the GAA? Despite the fact that, as a concept, UA is not evil per se.
I will stick, Your Honor, to the position of Petitioner Lagman, which is unprogrammed appropriation is not evil per se.
Thank you, Counsel. You may sit. Now, to the Solgen, reiterating the question previously of Justice Javier, in terms of the budget preparation and the GAA, why not just include unprogrammed appropriations under programmed appropriations? Why is there a need to distinguish between programmed appropriation and unprogrammed appropriations? And what are the real consequences if unprogrammed appropriations are removed or abolished from the GAA?
Your Honor, the mechanism of the unprogrammed appropriations has been used by the political branches in order to have the flexibility in terms of the fiscal space that the executive has deliberated on and has planned with regard to deficit level. So it works within a fiscal space, Your Honor, meaning if it is able just to commit to an X amount of revenues, then that means that the executive will undertake to earn those revenues in order to fund the programmed appropriations. Other than that, it does not find a power or capability to commit to funding other important programs which we find in the unprogrammed appropriations. So meaning, if all of the unprogrammed appropriations will also be included in the programmed appropriations, then there will be breach, for example, of the deficit level that they think is a sound deficit level. And if I may also mention that even the first world countries have a planned deficit spending. So deficit, having or adopting a deficit spending framework isn't inherently bad. And what the question should be is how sustainable it is. And maybe our representatives also from DBCC could explain that even in the medium-term fiscal framework, there is a target each year until like 2028 where the ideal level of deficit should be achieved. Deficit spending is not bad because if the executive and the Congress will invest in certain projects that have better multiplier, higher multiplier effect, then the economic impact will be more positive. So, Your Honor, it's actually the fiscal space that forces the executive to put in the unprogrammed appropriations. And again, may I reiterate that in unprogrammed appropriations, if there will be no excess or if the triggers are not attained, then there will be no funding for the unprogrammed appropriations, Your Honor.
Soldier. So, Soldier, the Constitution vests in the Congress the power of the purse. And the court recognized this in Pelconza versus Enriquez, as well as in Angnar's party list versus Executive Secretary. But the Constitution requires the President to submit to Congress a BESF, a Budget of Expenditures and Sources of Financing. Does this mean that the Congress is bound by the budget proposal submitted by the President?
Your Honor, with regard to the BESF, then the Congress is bound to observe the ceiling with regard to the BESF as presented. And it is our position that the unprogrammed appropriations being supported by funds that are not in the BESF, then they are not part of that prohibition.
The power of the purse granted by the Constitution is not unlimited, correct?
Correct, Your Honor.
So, this is not a purely political question.
Yes, Your Honor.
To what extent then can this court review the exercise of the power of the purse, particularly on the inclusion of the UAs in the GAAs?
Your Honor, it is the position of the respondents that there are constitutional provisions that we have to check vis-a-vis, or we have to use these constitutional provisions and see if there has been a violation, which is the Article 6, Section 25, Paragraph 1, which is addressed to the legislature that they may not increase the appropriations recommended for the operations of government. Article 7, Section 22 is also a limit. It refers to the BESF, and it is addressed to the executive, to the president, to submit that, and that the form, content, and manner of preparation shall be prescribed by law. Also, the provisions in the GAA must be related specifically to a particular appropriation and limited in its operation to the appropriation to which it relates, which is Article 6, Section 25, Paragraph 2. Also, the legislature is observing all the standards that the court has enumerated in Belgica 2013 and 2019. The test of germaneness, which has been laid down also in Atitio versus Zamora by the Supreme Court. So, Your Honor, it is our position that all these constitutional provisions, we check on whether there was a violation, and it is our position that there was none.
So in short, you are saying that the power of the purse is limited by the textually demonstrable and judicially discoverable standards laid down in the Constitution. Am I right?
Yes, Your Honor.
Can I call the counsel for the petitioner? Anybody from the petitioner's side?
Good morning, Your Honor.
Good morning, counsel. Now, do you agree that the power of review by the court here on the power of the purse should be based on this limitation or within the textually demonstrable and judicially discoverable standards of the Constitution? If
Your
no,
Honor,
why not?
Your Honor, please, it is our humble position, Your Honor, that it is, Your Honor, subject to those guardrails as specified in the 1987 Constitution, Your Honor, because it is precisely the point of the framers of the 1987 Constitution to guard this kind of events, Your Honor, in order for these powers not to be abused, Your Honor, by the Congress, Your Honor.
Is this not a question of policy, considering that these are stated and enumerated in the Constitution?
Your Honor, it is our humble position, Your Honor, that as stated in the petition of the late Congressman Edsa Lagman, Your Honor, it is our position that since the Constitution is clear, specifically Article 6, Your Honor, and Article 7 of the 1987 Constitution, it is our humble position that it must not be interpreted, Your Honor, but it must merely be applied, Your Honor, as enunciated in every decision of this Honorable Court, Your Honor.
So notwithstanding that there is no grave abuse of discretion, as long as there is a violation of the text of the Constitution, you are saying that the court can intrude into such issues.
Your Honor, in order for this it is our humble position, Your Honor, that in order for this Honorable Court to validly decide on the matter, there must be, of course, Your Honor, our humble position, there must be grave abuse of discretion on the part, Your Honor, of the agency subject of the case, Your Honor, as being held in this case, Your Honor.
Thank you, Counsel.
Thank you very much, Your Honor.
So to the OSG, what standard should this court assess the constitutionality of unprogrammed appropriation in the GAAs? What should be the guide of this court? Any jurisprudence saying what guide should we follow in assessing this?
Your Honor, the number one would be if there has been a constitutional provision that has been violated in recognition of the expanded judicial power of the Supreme Court. The other question is that if there has been grave abuse of discretion. And Your Honor, we found a case, Defensor Santiago versus Gingona, where the court had two issues on whether there was a violation of the Constitution, and number two, whether there has been grave abuse of discretion. Now, in Defensor Santiago versus Gingona, their number one finding is that there was no violation of the Constitution since the Constitution was silent on the manner of selecting the officers in both chambers. Now, they proceeded to the next question. If there is no constitutional violation, can the court inquire into grave abuse of discretion? And then the court proceeded to define what grave abuse of discretion, and if I may be allowed to read, yes, Your please. Honor, grave abuse of discretion is such capricious or whimsical exercise of judgment as is equivalent to lack of jurisdiction. The abuse of discretion must be patent and gross as to amount to an evasion of positive duty or a virtual refusal to perform a duty enjoined by law, or to act at all in contemplation of law, as where the power is exercised in an arbitrary and despotic manner by reason of passion and hostility. And the Supreme Court proceeded to say also that absent any clear-cut guideline, in no way can it be said that illegality or irregularity tainted Respondent Gingona's assumption and exercise of the power of the office of the Senate Minority Leader. And that where no provision of the Constitution has been clearly shown to have been violated, disregarded, or overlooked, grave abuse of discretion cannot be imputed, Your Honor.
Sergeant, what weight do you think is required to establish the unconstitutionality of a law?
Your Honor, it's proof beyond reasonable doubt, which has been cited in the municipality of San Mateo versus Smart Communications, which I understand was penned by your good self. And we also had a survey of several other cases which reiterated the same. So it is proof beyond reasonable doubt. It works on the presumption of constitutionality of the acts or of the laws that have been passed by Congress, and as also revealed in the last oral argument, Your Honor, when the good Justice Amy Javier also asked the petitioners, it is our humble appreciation that the petitioners were unable to give their justification for the allegations that they have included in their petitions, Your Honor.
Thank you. Can I ask any counsel on the petitioner's side? Yeah. Good morning, counsel.
Good morning, Your Honor.
Do you agree, counsel, that there must be a clear and unequivocal breach before a law, in particular in this case, the inclusion of the UA in the GAA, before it may be struck down? Or to prove unconstitutionality, there must be proof beyond reasonable doubt?
Yes, Your Honor. Which is in this case present, Your Honor.
Okay. So you agree with the good Solicitor General in her statement on the weight of evidence to strike down?
On the weight, Your Honor, but again, the position of the petitioners is that we have overcome the burden, Your Honor, for the unconstitutionality.
Thank you, counsel. So, Soljan, it seems to me that the guardrail imposed by the Constitution on program appropriation is the ceiling as contained in the BSF, as you stated a while ago. What then are the guardrails for the unprogrammed appropriations?
Your Honor, the same provisions of the Constitution, because it is our submission that the Constitution sets out the limits, the limitations to the power of government. And because the unprogrammed appropriations are not expressly provided in the Constitution, though it is our position that it doesn't necessarily mean that it is not allowed. Okay? Because we based on contemporaneous construction that the political branches have interpreted that it is within their power, in the power of the purse, to include the unprogrammed appropriations without violating what has been provided in the Constitution. So, Your Honor, I would still say that the same constitutional provisions that I have mentioned a while ago, including the guardrails that the Supreme Court has laid down in Atitio versus Zamora, in Belgica, in Araulio, on what constitutes an appropriate provision, the constitutional provision on riders, all of this should still be the guardrails. Number two, Your Honor, and so that's for the legal. The guardrails, as we have seen also when the Congress deliberated on the 2026 GAA, the Congress itself also has implemented a lot of reforms, so which shows that there is an opportunity, or they also have a way to course correct For example, in the PhilHealth as well, when the case has been brought to the Supreme Court, the executive has already made a pronouncement that it will restore the 60 billion to PhilHealth. So there are steps, Your Honor, that are being undertaken by the political branches. And the third, Your Honor, if I may add, the guardrails for the unprogrammed appropriations are also contained in these special provisions of when there should be a trigger, what are the triggers, what are the documentary requirements on the certification by the Bureau of Treasury. There are also a lot of processes that are also required upon the DBM. So not because there's already a certification, the DBM also has to have a packet of documents that they will evaluate if it is implementable right away, so that they will not park the sums to a project that is not executable right away, Your Honor.
Now, next question has already been passed upon by former Senate President Drinon earlier. But I go back to your argument that the court should not examine questions of policy. The 1987 Constitution grants this court the expanded judicial power to determine whether there has been grave abuse of discretion by the government. How does this interplay with your argument that the court should limit itself to determining the issues based on the textually demonstrable and judicially discoverable standards in the Constitution?
Your Honor, so we are guided by the Defensor versus Gingona pronouncement by our Supreme Court that if there are no textually demonstrable standards that are provided in the Constitution, then that could also mean that it is not a legal question. So if the Supreme Court would undertake to evaluate policy questions, then that means that the Supreme Court may then have to undertake a task that is open or given to, for example, Congress. So in order to come up with fiscal policy, a fiscal framework, the executive has a very long list of steps or experts to consult. The same way for Congress, in order to come up which program should go to programmed or unprogrammed. So in other words, there is a complete political process as well that can only be undertaken by the political branches. So there is, of course, an inclination when some institutions become weak at some points in our history, there is an inclination to bring the issue to the Supreme Court and look at the Supreme Court as the savior of our country. But it is our humble submission that if there is no textually demonstrable standard, then it is not a legal question, Your Honor.
How then should the court deal with issues where there are no textually demonstrable and judicially discoverable standards in the Constitution?
Your Honor, there is also the coordinacy theory, which actually recognizes that the interpretation of the Constitution is equally distributed in the other branches of government. So of course, the Supreme Court has the final say as to what is the interpretation, but the coordinacy theory could also be a way for the Supreme Court to take jurisdiction of a case, but could differ if it finds that there are issues, that there are no standards, or it does not fall under the grave abuse of discretion to to find jurisdiction but still defer to such questions as belonging to the other political branches, Your Honor.
So this coordinacy theory was discussed by Justice Renato Puno in his concurring opinion in Francisco versus House of Representatives. And he cited this because it is a framework in our constitutional system of separation of powers. Am I right?
Yes, Your Honor. So it's actually a means of reconciling the judiciary's counter majoritarian. So the three branches, the two other branches, the political branches are the majoritarian branches, and the concept of coordinacy was, I think, still in the 19th century. It was first published in the Harvard Law Review and also studied by our academics. One academic, Oscar Tan, says that it allows the judiciary to assume the jurisdiction, but could point to the political branches and how the actions can be permissible under the Constitution rather than handling its own interpretation. One academic also said that as the majoritarian branches, the Congress and Executive, their right to be wrong is greater than a judge's right to be correct on a question he or she is not supposed to be competent to rule on. And it is ultimately the electorate that are the final interpreters of the Constitution, since they have the power to amend it. That's a line by one academic, Your Honor.
So you were saying, Solgen, that if the issue involved only errors of judgment or pagkakamali sa pagpapasya ng other branches of the government, and there is no grave abuse of discretion, the petition should be dismissed in this case.
That is our position, Your Honor. At maaari pong dito, yung implementation po ang nakikitang pagkakamali. May mga reaction na rin naman po, yung mga chairperson of the appropriation is no longer the chairperson and is currently a fugitive. The House of Representatives also has undertaken a lot of reforms in the 2026 budget. We have witnessed also the live streaming of their deliberations. Both Senate and the House have implemented the reforms in the 2026 budget, Your Honor.
So what if Congress uses its discretion poorly in preparing the budget? Does this mean that the people are left with no resort?
It is our position, Your Honor, that the Constitution also provides the mechanism. So there's, although it's like post facto, but the mechanisms provided are ombudsman. There is the Commission on Audit. The Commission on Audit, each office, while it is undergoing its activities, should also be checked by the COA. The veto power, the President also can exercise its veto power. The anger of the electorate is also expressed. Civil society is also very alive and engaged at this point, and we feel their anger. They have been relentless as well, and cases have been filed, and with reason. So these are all mechanisms that are provided without relegating to the background also another pillar of the constitutional framework, which is the separation of powers, Your Honor.
You know the case of Cotes Coop versus Secretary of Education?
I came across this.
This was penned by Justice Kagiwa. And Justice Kagiwa said here that policy matters are the exclusive dominion of the political branches. The court will not look into whether a law is wise or unwise based on sound economic theory, and it is the best means to achieve the desired results. So you are saying that these are matters for the judgment of Congress, even if there are serious conflicts of opinions. Therefore, even assuming that Congress uses its discretion results in an unwise or a bad policy, this does not make the issue justiciable.
Yes, Your Honor. I remember coming across that decision, and I put that in the notes to also support the position of the government, Your Honor. We are imagining the temptation really for some branch in the government to address the issues that have been raised to our attention, but we focus on what is the legal issue at hand, and it is on whether the unprogrammed appropriations are unconstitutional or whether there has been grave abuse of discretion, Your Honor.
So in Angara versus the Electoral Commission, the court noted that the Constitution has recognized the judiciary as the rational way, in fact, the only constitutional organ in checking the political branches of the government, especially in times of great disquietude or political excitement. Do you agree with those who assert that given the scale of the alleged corruption, quote unquote, made possible by the UAs, the court's action is exactly required in this case, in these times of disquietude?
It is our position, Your Honor, that there really has to have, we really have to have reforms or changes. But it is our respectful position that because of the reasons I cited a while ago with regard to no constitutional violation, no textually demonstrable standards, then the reforms have to be undertaken using the mechanisms also provided under the Constitution and the political branches themselves. We have had a briefing as well by Congress as to what their reforms have been. So, like we are told that there is now the BARC, the Budget Amendment Review Subcommittee, which is a 21-member body representing majority, the minority, and majority and minority political leaders. So, meaning they have also injected some transparency measures, and the BARC recommendations are still to be reviewed by the Appropriations Committee and then elevated to the plenary in order to ensure that there is not a limited number of people who are passing and studying the items in the proposed in the GAB, Your Honor.
Thank you, Soljan. You also mentioned that the Constitution provides for mechanisms to correct unwise policy decisions like the electoral process, the ombudsman, audits by the COA. But these corrective measures appear to be after the fact, when disbursements have already been made, monies have already been expended. Now, are there safeguards before the fact or before disbursements? And are there rules in place to prevent abuse?
Your Honor, I would point to the provisions that are present in many bills, in several bills that are pending in the House and in Senate. It seems to us that when we survey the pending bills, these are in the right direction. So the bills contain like a cap for the total proposed expenditure. So there's a target deficit level. They also are deliberating as to what are the triggers and to already legislate on the triggers so that it doesn't have to be dependent on the administration. There are also some scenarios which they hope to address, like if the DBCC determines that there is a risk of breaching the fiscal objectives in the MTFF, in the medium-term fiscal framework, then that will be prohibited. So it is our submission that the House and the Senate are all deliberating on this in order. These are now like found in the medium-term fiscal framework. So there's a target, but in order to legislate it, the Senate and the House are currently discussing these pending bills, Your Honor.
What about this power of congressional oversight? Is this material in this case?
Yes, Your Honor. So the agencies, after the passing of the GAA, so when the Congress and the Senate can call on agencies with regard to how they have been implementing, are they utilizing the funds that they have been granted in the GAA or the unprogrammed appropriations, and in many instances, corruption or violation of the laws have been raised and highlighted because of congressional oversight, Your Honor.
Soljan, you mentioned about this earlier. Constitutional system also protects itself through built-in self-correction mechanisms designed to adapt to changing societal needs. The court would therefore like to understand whether the UA framework has evolved over time to correct itself. Can you cite some self-correcting mechanisms which Congress and the executive made for purposes of making UA or going out of these questions on the UA?
Yes, Your Honor. So for one, the triggers, Your Honor, have been evolving also. There were periods of time that savings were part of the triggers. Later on, and since 2015, it has, I think, crystallized into the triggers as they are now articulated. Now, a second point is the pending bills on the budget modernization. So there is now in the 20th Congress filed or introduced by Senator Erwin Tulfo, and then the House also has a corresponding Budget Modernization Act filed by Kong Romualdez in October 2025. And then a third correction may be, a third correction, not maybe, there were significant changes also from the 2024 GAA to the 2026 GAA, like the amounts have been significantly reduced from 731 billion in 2024. In 2026, it has gone down to 150 billion. Number two, of course, because of the guidance of the Supreme Court also, the special provision 1D has been removed. And so there are only 3 triggers for the release of the UAs in 2026. In 2025 and 2026, the President also exercises power to veto. And under the 2026 GAA, there are only 3 purposes for which UAs may be used, unlike in the previous, which was a long list of UAs. So now it's limited to support to FAPS, revised AFP modernization program, and program on risk management. And also the last would be the Bar C. And may I add to the Bar C, the engagement also of the civil society organizations. They have a dedicated a day, or if I remember correctly, 3 days for the civil society to submit questions and to really check on the programs under the departments, Your Honor.
Okay, so the government is saying that the UA framework has not remained static, and that both Congress and the executive appear to have made adjustments over successive budget cycles. From the government's perspective, what significance, if any, should the court attach to this continuing evolution of the UA framework?
Your Honor, that we hope that this honorable court would see that the constitutional framework, in fact, we could say is working, because the political branches who must really be sensitive to the political processes have become sensitive and are doing their best to correct what wrongs have been done. And so also in recognition that if a power is lodged in another branch and without violating the Constitution, that the Supreme Court may find its favorable consideration in allowing them to course correct or to self-correct, Your Honor.
So, Soljan, you're saying that this evolution is relevant in determining the appropriate scope of our judicial intervention?
Yes, Your Honor.
Now, assuming the court identifies areas of concern in the operation of unprogrammed appropriation, must the court necessarily invalidate the mechanism, or should the court just articulate constitutional guardrails while allowing the political branches to continue refining the UA framework?
Your Honor, we believe that the Supreme Court can elucidate on the powers that are lodged in the branches of government, and which constitutional provisions should guide. But there could be also reminders to Congress as to the budget modernization bills, because they're in the right direction. We are all hoping that it should be passed sooner than later, because many of the issues that we are discussing here are contained already and being deliberated in the hearings for these bills, Your Honor.
But not to declare the unprogrammed appropriation unconstitutional totally?
No, Your Honor. We believe that the unprogrammed appropriations are not unconstitutional, and the guardrails for the unprogrammed appropriations, if they are to continue as a mechanism, will then be contained in the budget modernization laws that we hope should be passed soon, Your Honor.
Now, Soljen, have you examined comparative budgetary practices in other countries or jurisdiction on standby spending authority? And are you aware of comparable budgetary mechanisms like the program appropriation in other countries? Can you cite a few if there are?
Your Honor, there is one that is like closest to us, which is in Peru. Your Honor, I have it in my notes, Your Honor.
I think there's another one in Chile.
We
Mexico?
didn't find the. I only have Peru, Your Honor. There are two kinds of budget modifications similar to our unprogrammed appropriations. That should there be excess funds, the Finance Ministry would send a copy of resolution indicating the existence of such funds, and then given to the Peru's Congress.
So in assessing the constitutionality of a challenged budgetary mechanism just like the UA, should the court consider the budget practices concerning UA in other jurisdictions? If so, to what extent?
Well, not necessarily, Your Honor, but of course it may be helpful as well to see how other jurisdictions have been addressing in terms of like best practice that could also guide our Congress in passing the budget modernization bill. So I would think that they should be checking and comparing their budget processes with the other jurisdictions. But I say not necessarily, because each country will have its own peculiar circumstances with regard to, for example, I'm not sure as to how fast or how flexible their system could be, which is the one that is being addressed by the mechanism of the UAs in the Philippines, Your Honor. So to a certain extent, to check as to what are global best practices would be very helpful and insightful in order to, and we hope that they will guide our Congress in passing the budget modernization bills, Your Honor.
Thank you, Soljen. That's all.
Thank you very much, Your Honor.
Chief, can I call on Congressman Salceda?
Congressman Salceda.
I think there is some news that you'll be the next Finance Secretary.
Are you appointing?
So, Congressman
Good morning,
Salceda.
everyone.
Hey, good morning.
Sir,
From the government's perspective, what practical purpose does UA serve that would be difficult to achieve through ordinary program appropriations alone?
the word is magnitude.
Can you
Kasi
explain?
yung contingent, hindi yung kakayaan. Usually, you put 10, 15. Tapos, so in other words, as a standby for, let's say, a major disaster like Reming, Pepeng, Ondoy, the ability of the government to respond, you see, there is a golden rule. Kailangan, until you can save the very last life, that is the golden rule of disaster risk reduction. So kung hindi mo masave yun, failure ka, ibig sabihin hindi mo pinagandaan. Kaya yung size, hindi ko kakayanin ng contingent, at saka it takes yung sa, in general, I think the average would be 62 days before you can come up with a supplemental budget. assuming that there are savings that you can squeeze.
So you're saying that it's the size and the time element.
Correct, sir.
Okay. So you mentioned about the COVID-19, Ondoy, Pepeng typhoons in 2009.
Yes,
that were funded by the UA.
Yes,
Yeah.
sir.
So can you cite other instances when the UAs were actually used to fund emergencies and unforeseen expenses aside from those three?
I've been, I was thrown to the other side of Congress, which is looking for money. So I can I just submit that?
So, but there are lots more.
Bihira, sir.
Bihira.
Bihira na makita ng publiko. Pero alam ko marami.
Okay. So, in your submission to this court, you discuss about RA 992, the Revised Budget Act, which was enacted in 1954.
Yes, sir.
RA 992 allows the creation of a Budget A and a Budget B, according to you. And that was long before the creation and long before the 1987 Constitution. The Philippines already had this Budget A and Budget B. Can you elaborate on Budget A and Budget B?
Yung in-explain po dyan, sir, kasi every time, sir, nag-ano tayo ng bagong lahat ng konstitusyon ng Pilipinas simula 1934. Constitution muna, which is envelope A, then Budget Reform Act, which is your envelope B. So in other words, there is a conscientious, there is a deliberate, it is very deliberate for the body politic na iwala yung constitution at saka yung budget.
So, you are saying that Budget B is essentially a standby spending authority.
Correct, sir.
Would you consider Budget B as the equivalent of what we now call in the budgets as unprogrammed appropriation?
I have to study my... Okay.
Any opinion on this matter?
Layo pa ng... can I come? I don't want to guess, sir. But,
just a guess, an intelligent guess.
But the way it was designed, essentially, they separated the two.
Okay, so, but this is a standby spending authority.
Correct, sir.
And this standby authority structure predates the 1987 Constitution. Am I right?
Since 1934, nung binigyan tayo ng independence, so may constitution doon, tapos may Budget Reform Act. Noong 1937, nung nagkaroon na tayo ng independence, separate yung constitution sa... So we had a series of, I think, 5. So iba yung constitution, nauna yung constitution, then sumusunod lang po yung budget reform.
When the framers drafted the 1987 Constitution, would it be fair to say that they did so with the knowledge of this you call as standby spending authority?
I think there would be a sense because there's a recognition that the Philippines is really typhoons. You have typhoons, you have volcanic eruptions, everything. So I think that would be embedded in many of the provisions in the Constitution.
Okay,
especially on the overarching philosophy was social justice. Yung nasasakta naman po talaga ay mahirap. So I would say that in recognition of the fact that the Philippines has 19 to 21 typhoons, we have earthquakes, we have everything. So I would say, sir, that it permeates the entire philosophy of the 1987 Constitution.
Thank you, sir. That's all.
Sir, can I just make?
Please.
Sa tingin ko, pwede naman kayo makialam. I don't know whether it is proper for the Supreme Court to define what a BICAM is.
So, just a day ago, in the Inquirer column of former CJ Panganiban, he commented on the present Senate deadlock. He said, and I quote, "While the judiciary has the expanded power and duty to check grave abuse of discretion, historical wisdom warns against prematurely and unnecessarily dragging the non-political robes of the justices into partisan landmines. Until all internal political remedies within the chamber have been fully exhausted, the court should be spared the job of legislative intervention." Can I ask former Senate President Drilon on this? Sir, in the context of appropriations, how do you reconcile the court's constitutional duty to check grave abuse of discretion with the existence of self-corrective mechanisms and legislative measures being done apparently to address these issues?
Your Honor, can I have the question again? I couldn't get didn't get it well.
So, you heard the statement given by Justice Panganiban, or do I repeat it to you?
Yes.
Okay? So, in the context of appropriations now, sir, how do you reconcile the court's constitutional duty to check grave abuse of discretion with the existence of the self-corrective mechanisms and legislative measures being done by Congress to address this issue on unprogrammed appropriation?
Your Honor, with all due respect, I think this court should allow Congress to adopt self-correcting mechanisms, because it is our humble submission that in the unprogrammed appropriations is part of the power to include unprogrammed appropriations is part of the power, an inherent power of the legislature to appropriate funds. And if I may, Your Honor, the existence of unprogrammed appropriation really is something that is difficult to justify in terms of the overall budgetary process. Because from my experience, Your Honor, and if I may share it with the court, when the budget committee would present the budget to the Congress, and we raise questions on the unprogrammed appropriations, the response to us, Mr. Chief Justice, is that we include the unprogrammed appropriation because it is not considered as part of the program deficit. But that is the rationale for the practical rationale for the unprogrammed appropriation. But if you look at it more closely, Your Honor, the President has all the powers under the Constitution insofar as the budget is concerned. From the way I see it, Mr. Chief Justice, the President is very powerful. It can be a one-line budget, and it can be operated by the President. He has veto powers, he has line item veto, and the most important, he has the power to withhold releases, even if there is an appropriation. And he can also augment items in the budget. All of this make the president very powerful, and we have only a one-year budgetary law, and the president can do anything. So really, while I am of the sincere belief that unprogrammed appropriation is part of the inherent power of Congress to appropriate, power of appropriation, the fact that the president has vast powers over the budget under our system makes really the unprogrammed appropriations unnecessary. In other words, what you intend to achieve through the mechanism of unprogrammed appropriation can be achieved anyway, even without the items there. I repeat, sir, we have only a 12-month cycle, so that the lack of a program appropriation would not really harm government operations, because, the president can always call for a special session, can always work with the committees of the two Congress to pass the needed legislation in order to allow spending in areas where the president finds it necessary to spend. That's our respectful submission, Your Honor.
Thank you, SP Drilon. That's all, Chief.
Chief, with your permission, can I just ask the Solgen? Since you mentioned a while ago that there are reforms that are being done in the budget process, just for clarity, can you submit to the court at the soonest possible time the resolution of the House or the Senate on these reforms, or better still, if we missed a new law that actually provides for these reforms, or is just this part of your consultations with your client? So since you mentioned to the as responses to Justice Rodil Salameda that there are reforms, please do not forget to submit what these reforms are, preferably in the form of a resolution, if it's in a resolution, or maybe it's just a bill for our information. Thank you.
Yes, Your Honor, we will comply. Thank you.
Considering that it's exactly 12 o'clock at the court's clock, we'll suspend the session for lunch break and then resume at 1:30.
Please rise. Please remain standing while the Chief Justice, the Senior Associate Justice, and the Associate Justices leave the session hall.